as you heard, this is meant to be an engaging discussion. Feel free to reach out online, ask questions. What we respond with is not legal advice, right? There's more specifics required, but we are giving you a really good view of what's going on in a lot of ways right now. So quick housekeeping, there are CLE credits, so please make sure you have signed in. So I'm Nate Downing, I'll be moderating this panel. They're the experts on this panel. I'm here to ask questions, so if you have a question, you'll be wanting to hear from them. But I work at Gardner Law, I'm a managing attorney, I lead the regulatory practice, and have a really big focus, obviously, on FDA, also touch on some EU things, and there's such an intersection with privacy in the way you got to get products on the market, encompassing compliance, regulatory, and privacy, that the full scope of today's program should give us a great launching point for any topic that we might have related to this information. And I'm going to hand it off to each panelist to introduce themselves.
There we go. Good morning. Hi, everyone. My name is Paul Rothermel. As Nate mentioned, our practice at Gardner also emphasizes privacy and AI in that respect. So artificial intelligence, as you know, is a significant area. And so we'll be talking about that from a US perspective, from an EU perspective, and UK perspective. My practice largely is focused on privacy, AI, technology matters, cybersecurity as well. So things like HIPAA, the state privacy laws, CCPA, which is very relevant here in California, but also many other state laws that impact how we use and handle data.
Oh, thanks, Paul. I'm Felicity Fisher. You'll see everyone refer to me as Flick, and you're welcome to do the same. So like Paul, I'm a sort of privacy and digital regulatory lawyer, UK qualified, but help run our Silicon Valley team. So Fieldfisher is a European kind of headquartered law firm, but some of us are lucky enough to work out here in our Silicon Valley office, and I'm one of the few partners that runs the team out here. So I spend my days advising our US clients on kind of European, UK privacy, digital regulatory matters, and that at the moment involves a vast amount of counselling on AI related matters. So very much looking forward to this discussion.
Thanks, Flick. Hi, everyone. I'm Oliver Sume. I'm with Fieldfisher as well. I'm a partner in the German office and co-heading the technology sector practice of the firm. I'm doing technology and privacy data protection law for more than 20 years now, in particular with many clients from the life science sector, medical device companies, and well, what keeps me busy currently, AI, that we will have on the panel here today, is a huge topic, in particular from a European perspective. We have a very strict regulation, as many of you might heard. And that combined with the strict requirements under GDPR is a challenge and confusing sometimes, and I'm trying to help my clients out of that. Thanks.
So as we kick it off, we're going to do like a Q&A session, right? But there's also some slides that you'll see, and those are really good information. So in your packets, you can refer to those, review those if you have questions. Those are really a great, information, but here we're really looking to have a discussion, so that's why those slides are included. So I'm going to ask a panel to the question, and this is going to cover US, EU, UK. How is artificial intelligence defined in the UK, EU, US, and where does that definition stem from?
I think I'm going to let the EU side respond to this first. It's a little more clear in that area.
I have to read it to you because it's really kind of funny. So under the AI Act, an AI system means a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that explicit or implicit objectives infers from the input it receives, how to generate output such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So no one really understands what that means, and that, to be honest, leads to a lot of uncertainty. It still refers very much to the definition that is also used on the OECD level. So that was the goal, to keep like at least an international global approach when defining AI. but still, and you hear it from the definition that I read, it is very, very broad, and a key question, of course, if a certain system is considered as AI, with the consequence that it falls under the scope of the European AI Act, or on the other hand side, if it's still just usual software, which would mean that it's not regulated. And that is, well, so to say, the entry gate of the whole act is already providing for some uncertainty.
Yeah, and from the UK perspective, you'll see as we kind of get into the discussions that the UK has taken a very, very different legislative approach to regulating AI. So we don't have an equivalent of the AI Act. And the UK government has very much pushed an agenda of we're going to have a principle-based approach and a flexible based approach to kind of regulating AI. So they are very much positioning their approach as pro-innovation, particularly compared to what's seen as a very regulated approach coming from the EU. And aligned with that sort of approach of not having a sort of equivalent of the AI Act, we've got quite flexible definitions of what AI is under the UK kind of guidance and principles. But essentially, they're talking about machine learning type technologies that are there to replace kind of human processes and decision making and things like that. But aligned with their approach, it's very much looking at the type of scenario that you've got, the type of use case, and the risk associated with that particular AI use case, as opposed to strict definitions.
And I guess we're on a little bit of a spectrum here, going left to right. So as you look at the US definitions around AI, primarily we're looking at state laws. And so far, there's not a lot of those that address AI generally. So we see some generative AI regulations, for example, in California, and those rules focus on particularly things like ChatGPT, Gemini, these other tools that are used by individual consumers that are used to generate text or other things. But there is a focus in many of the privacy laws on automated decision-making technology, which touches on AI. It's not exactly the same as AI, but it gets into that realm. So we see some regulation around that. Particularly California has released some regulations on automated decision-making technology in particular. And so that influences a kind of technology that makes significant decisions without human intervention for individuals who are, whether it's provision of healthcare, denial of healthcare, different things that can impact them. So the definition there is more about the use of that technology and how it's deployed. And then in Colorado, we have a definition of AI within really the only general AI system law in the US right now that really is similar to the EU AI Act. In a way, it's a little bit lighter on text. And as Oliver said, I don't think I could quote it from memory, but an essential part of that is that it influences virtual and physical environments through the use of these technologies. So it's a system that influences environments in some way. So there isn't this sort of narrow focused, here's an AI system. It's kind of a broad, intentionally, I think, definition that's designed to capture some ambiguity in future technologies that we may not understand yet or be able to point a finger to yet.
Yeah, and I think it's also worth saying, I think the Californian rules that have come out have been inspired by the European concepts of automated decision making. So under the GDPR, we specifically regulate automated decision making that has a significant impact or legal effect on individuals. So we're really looking at sort of algorithmically driven decisions or AI model outputs that could really have a significant impact on people's kind of rights and freedoms or their access to healthcare or perhaps clinical decisions that are made about them. And that's quite clearly regulated under existing privacy laws in both Europe and the UK. It's Article 22 under the GDPR. And if you're doing that type of automated decision making, then essentially the law says you're prohibited from doing that unless you meet certain conditions. So it's kind of a slightly different to the Californian approach, which is you can do it provided there's pre-notice and some kind of opt-out. In Europe, it's a slightly higher bar under the GDPR for enabling that automated decision making. We're starting to see more and more scenarios, particularly around clinical decision making, where we're falling into that automated decision making, and then it gets regulated. And lots of that decision making is powered by AI now, so it kind of pulls AI into that scenario.
Thank you. So as you're starting to develop a product, if you think you might have AI elements, you can already see across 3 different jurisdictions the kind of work you have to make sure you're properly defined. Let's take that a little step further now. How is AI regulated for a life sciences application versus more of a general application, and what is the impact of that to industry?
So the European AI Act basically takes a risk-based approach, and the principle is the more risk-based a certain AI technology is, the more compliance requirements you will have to meet as a provider or deployer. The interesting thing about the life science sector, and in particular medical devices, is that as soon as a medical device has an AI system embedded, it will always be considered as high risk, which means not only that you have to meet the highest requirements under the European AI Act, but in particular, you need to undergo a new certification process, a conformity assessment. And that is something that, keeps the notifying body very busy currently. This part of the AI Act will only be applicable from August 2027, which seems like to be far away from now, but it will take time to get the new assessment and the new certification. So yes, for medical device manufacturers that are using AI within their technologies, it's really challenging, and we're always advising clients to start their internal assessments as soon as possible.
Yeah, I think a key part for life sciences to keep in mind is when you're looking at these laws, many times they're not designed with life sciences in mind within the US. So we have, say, Colorado's AI Act right now, which has been delayed. The effective date of that for enforcement is out into June 2026 now. But when you look at those laws, what they do provide is usually an exemption for, in Colorado's case specifically, for something that's been approved through a substantially equivalent or similar process within federal law. So we have, by a federal agency, so we have some ways to look at, does that mean all FDA approved products, or is there some, like similar to the EU, some overlap where there may be some additional steps to take to address those AI laws within the state? Similarly, when we're talking about the automated decision-making technology, if you're looking at what is a significant decision for an individual, provision of healthcare, does that cover life sciences applications? Probably some of them. So there's some analysis that needs to be done to address when a life sciences application of the law does impact those products.
And then just to kind of complete the UK perspective on this, so as I mentioned, we don't have an equivalent to the AI Act. And in fact, post-Brexit, we're dealing with medical device regulations that are dated back to 2002, so quite an outdated set of regulations there in the UK. And so what the MHRA, which is the sort of regulatory body for medical devices in the UK, they have been tasked through the UK government's kind of policy approach of coming up with principles, guidelines, and regulatory reform to kind of specifically regulate AI in medical devices and software as medical devices within the UK. So they've got an extensive kind of roadmap that they have laid out and a plan for kind of better, I guess, supporting and providing guidance and processes around how we kind of regulate AI in medical devices moving forward. But it's quite a different approach to Europe. So we're sort of waiting for them to publish quite a lot of their guidance. They're trying to align more internationally with more international standards than Europe. But essentially, if you've got an AI tool that has a medical purpose that is involved in kind of clinical decision making and things like that, then it's going to be regulated within the existing regime, and therefore we need to look to the guidance that comes from the MHRA around how we sort of integrate AI and use AI in a compliant way.
Yeah, I think if you look on the screen right now, it's showing the growth of AI. This is FDA focused, but you can see there's ambiguity, but it's not like products aren't getting onto market, right? So some of your regulators certainly have experience, they know how to move it, but it's not always well defined from a top level, right? So it takes a lot of work to figure out how to define your product, what's going to be required to get it on the market. And I'm going to ask a question for the panel that brings in privacy and data protection and all of those things. So there's a lot that's being done, but there's also more that can be done to make it easier on industry to have predictability and to really know the path to take. So, you know, that's a great slide just to show it's going up and it's going to continue to do so, though we're not always up to speed from a regulatory standpoint, rulemaking, lawmaking, that type of thing. How do data protection and privacy laws interact with the use of AI?
Yeah, that's a very good question. And exactly that is the challenge for many companies also beyond the life science sector, because of course GDPR still applies. And if you know some of the basic principle of the GDPR, you of course understand that it seems to be a little bit of a conflict maybe because, for example, the GDPR knows the principle of data minimization. You're only allowed to use as much data or data processing of personal information that is really needed to fulfill a certain purpose. And that actually more or less is contradicting what the basic of large language models is, because the more data you have, the more data you can use, the better the outcome of a large language model, for example. And that's really what is challenging. Yeah, you need to comply with both on top of what is regulated under the medical device regulation in the EU. So it's really a challenge. And in that respect, I must say the AI Act is a bad regulation because it does not clearly define the overlap between GDPR and AI Act. It leaves it to the industry, if you will, to think about how you can solve this. It's really challenging.
Yeah, I think there is an inherent kind of conflict that's emerging between the requirements around, you know, good AI governance and thinking about the types of information that you use to train, validate, improve models requires often a vast amount of data. And in the medical device life sciences space, we often need sensitive personal data to properly train some of these models. And that leads into a conflict with European data protection law, where the general rule is we're not supposed to be using sensitive data unless we can meet certain elevated compliance requirements, and some of them are quite hard to meet under the existing kind of conditions that apply there. So the UK has been trying to sort of improve on its data protection laws through some targeted amendments that have just come out in June, actually, through the Data Use and Access Act. So post-Brexit, we're now free to legislate independently of Europe, and in line with our approach to try and sort of be a centre of excellence for AI and a place of real, you know, to really encourage innovation in the AI space. We're kind of seeing that come through in some changes to the UK GDPR. So more recently, well, in June, some of those changes include sort of more permissive rules around secondary use of data for research purposes, for example. And so we could start to see through the divergence in the UK regime a little bit more flexibility around how we use some types of personal data for research and relatedly kind of training and improving AI models. And I did notice as well that we've got the digital omnibus kind of package that's been released, well, is due to come out on the 19th of November. That's a package of reforms, targeted reforms that Europe is looking to make to some of the existing package of regulation in Europe. And interestingly, I saw sort of word on the street that they're thinking of introducing some changes to the GDPR to allow a more expansive view on what counts as a legitimate interest for using personal data to train AI models. We might, you know, there's a long way to go through some of those change suggestions, but we could start to see them make some changes to better support the use of data for, you know, AI-driven innovation.
Yeah, I'd say in the US, one of the areas that has gone relatively well, I think, for life sciences is that we have HIPAA and these other laws that can provide some certainty as far as when you're going through the clinical research, you're developing a study, you're sponsoring that study. Typically that data, if you do the consents properly, if you do the agreements in a way that allows for it, you can do a lot with that data without some of the restrictions that we might see in a European model from a data protection standpoint. I think outside of those particular kind of healthcare, we have the data through a research study. Outside of those environments, it can be more challenging. We see a lot of different, the patchwork of US privacy laws can be very tricky when you're dealing with things like consumer data or direct to consumer information that's not part of the HIPAA bubble, if you will. So that is where we see the rubber meet the road in terms of when is consent required to use AI? What does de-identification look like outside of HIPAA within these state privacy laws? And so that can be a challenge. We typically are seeing a variety of different approaches there. Often de-identification is the goal, but the standards are not as clear when you're outside of the HIPAA realm.
And actually, sorry, just to make one important point there, actually, because I see it come up a lot, which is the kind of standard for de-identification under HIPAA is quite different to the standard for anonymization in Europe. Unfortunately, for lots of research scenarios, our standard for anonymization is a lot higher. And we also have this kind of separate bucket of data, which we call pseudonymized data, which is essentially our version of the HIPAA de-identified data. And we still treat that de-identified data as personal data, and so it still remains regulated. If we want to anonymize data and to take it outside the scope of the law and therefore have fuller reign or freer reign over how we use it, we're talking about meeting an incredibly high standard, which is in practice often makes the data less useful. And so there is that battle there as well.
Yeah, interesting. I think, the next question is really something that kind of gets to the crux of the issue of the way we're all speaking right here, right? There's different regimes, different ways of doing things, but that doesn't help companies who have to make one product, right? Now, understand the knowledge of, but the way EU, UK, and US work together isn't helping companies. And so are there challenges or best practices for harmonizing compliance across regions, dealing with privacy, AI regulations that are different from each other? How can companies really be impactful, efficient at actually getting these issues and tackling them head on so they can have some predictability in the time to market and to the protections once they're on market?
Yeah, from the US perspective, I would say often because of the really enormous differences between particularly HIPAA and how that data and how it's applied to companies in the US and the EU standards, we're typically seeing companies separate some of that activity. And so it's very difficult to harmonize it internally. There's just very different rules. The data that's subject to those rules is different, and the impact can be challenging. So we see a lot of companies diversify and separate those functions, at least from the US perspective. Beyond that, I think the state rules have thrown another wrench into that, but I think to a degree, those are at least a little bit more harmonized with EU standards in terms of typically secondary use is handled the same way. The coverage of that data is a little bit broader. So it can be a challenge. It certainly can.
Yeah, I think one of the things you can note across the different regimes is there's obviously quite a lot of divergence in how we specifically regulate AI and how we regulate the processing of PII or personal data. But if you look at it from the perspective of some of the risks that we all need to be thinking about when we're integrating, building AI tools, a lot of those principles are kind of common across the regimes that we need to be thinking about. These concepts of transparency, explainability, safety. So actually, one of the things that you can start to do is think about an AI governance program that starts to tackle these principled level requirements that are going to hit a lot of the issues that you need to be thinking about under lots of different regulatory regimes. I think a starting point for that is actually understanding what AI you're using, building, developing, integrating, because only then can you start to get a handle on what you need to do to kind of implement the right kind of compliance. So I think it all starts with some kind of important internal inventory and mapping exercise, and also thinking about what principles you as an organization need to stand behind when you're using AI within your organization, because a lot of that's going to be driven by regulatory requirements, but there are also emerging kind of governance frameworks and principles that apply across different legal regimes or that are common to them.
Yeah, no, very good point, and that's exactly what we see at many clients happening currently as well. AI governance is really the key project here for many companies. And that means, of course, yeah, understanding your own processes in a first step, and have an assessment to what extent you might already have AI in different departments of a company. And the bigger the company, the more international, the more complex is this challenge. So it's really an internal assessment, internal homework that you need to carry out. And then, as Flick rightly pointed out, think about how do I integrate a new compliance structure into my existing compliance structure in the business? Will AI governance be part of my legal department? Will it be part of my compliance department? How do I create a policy that is dealing with how my employees are allowed to use AI or not, to what extent? That's something that I think is a really fundamental homework that every company, regardless of the sector, actually needs to carry out currently. And what might be helpful from a global perspective are the OECD principles on AI governance. So that is something that we see as a global approach. It's of course general, but we see some, well, global principles that are the same. It's all about transparency. It's about documentation. It's about compliance. And that can be, so these principles might be a starting point for developing a global internal AI governance structure.
That's great advice. You've got to be able to integrate everything and just make it part of your culture. We do have an online question, so Paul, go ahead and make your statement. I'm going to walk over, but just a reminder to in the room, if you have questions, feel free to ask. I'm going to do an online question during Paul's comment, then I'll swing over to you.
Yeah, I was just going to add, I think that's a really good point, that despite essentially the lack of or light regulation in the US on AI specifically, it can't hurt, and it certainly companies are looking at AI from a risk management standpoint, and how do we ensure that while it's not necessarily a regulatory issue in every state or in every case, we still need to consider some of these risks, and those risks are, potentially patient harm or misinformation that the company may produce or use internally, IP issues. There's a variety of concerns with AI, that privacy issues, of course. There's a variety of concerns that need to be addressed, whether the regulations require specific programs or risk assessments or not.
All right, so we have a couple questions online. The first one is, because the EU AI Act is horizontal and extraterritorial regulation, does it imply that this law is applicable to the US and UK and across other regions if you intend to supply or put in place your AI products or systems? So I think the question is, if you aren't located in the EU, but you intend to sell your AI product in the EU, does it apply to you?
The answer is quite easy, yes. No, it's the AI Act takes, like many European regulations, an extraterritorial approach. So it applies to every company that wants to place systems or products on the European market that, in this case, imply AI systems.
Great, thank you. And one more. I think this is Sir Flick. To your comments about a difference in research data and the slides breakdown of clinical chemistry, are there developments in using AI in the R&D space that complement clinical trials? For example, pharmacopoeia compliance testing, or is the focus here just clinical data?
Well, so the focus of the UK data protection laws, like the European data protection laws, is on the processing of personal data. So we take a technology neutral, sector neutral. It's all about processing personal data, and we have particular provisions in the law that deal with processing of personal data for research purposes. And for a long time, certainly under the EU GDPR, there has been a bit of a battle over what counts as scientific research for the purposes of some of those provisions. And we've now got a little bit more guidance from the European side, which takes, I think, a slightly more restrictive view on what counts as scientific research versus what we're starting to see come through from the targeted amendments to the UK data protection laws. So slightly, they've put on a statutory kind of footing acknowledgement that certain, privately funded research activities, commercially focused research activities, anything that can be reasonably deemed scientific is now going to count as scientific research. And that has some particular implications, because it now means that we can, if we are doing scientific research, we can start to take advantage of some of the wider, more permissive rules around using and reusing personal data for scientific research purposes. So naturally, that is going to play well, I think, to anybody who's doing kind of clinical research. And yeah, so I hope that answers the question.
Thank you. We do have one question in the room too, so I'm going to hand the mic over.
Hi, everyone. This is a little bit of a leading question for Flick because I actually have worked with Flick a little bit, but curious if you could all opine. You talked about the different regimes and the challenges with, what regime you're going to be operating under. But if you're a global company, how do you go about defining terms? I mean, on a very basic level, I know we've talked about when we talk about personal health information in the US, that has a certain definition and a very different definition in the UK and the EU. So how do you advise clients? How do you go about operating? At what basis do you just try to say, hey, these are the words we're using, and these are the definitions we're using, and then from there?
I'll let someone. I can give you my answer, Alex, but you might want a different perspective. So do you want to answer?
You know, the challenge actually is to find the lowest common ground for definitions, and that's where where available, global principles can help. I was referring to the OECD and AI principles earlier. With regard to, well, the different privacy, data protection, GDPR laws, it's more challenging because, as you rightly said, the definitions about what has to be considered personal information under the GDPR compared to HIPAA is not completely, but significantly different. So yeah, that's the more challenging part. I would say, actually, with regard to the AI principles, it's a little bit easier compared to definition of personal or health information.
Yeah, and I would just add to that. I think it's very difficult to come up with a sort of global set of, if we're focused on data protection issues, for example, a global set of data protection terms. We've partly because Europe is very prescriptive about what terms we have to have in place. If, for example, we're a data processor, we know we have to have a data processing agreement in place. If we want to start reusing our customers' data and we're a processor for secondary purposes of, improving our AI models, that then has certain implications because we switch from being a processor to a controller. And so that then requires specific terms to address that ability to wear a different hat for that secondary use. And because we then have different definitions of de-identified data under HIPAA versus the anonymization standard under the EU, I think you're putting a lot of pressure on a set of terms if we're trying to come up with just a blanket set for everybody. So the reality is, and you'll see this across many different, even outside the medical device space, just looking at a standard SaaS solution, you end up having to have a particular set of data protection terms in the form of a DPA, a data processing agreement for Europe. You can then start to layer in, CCPA and other requirements into that DPA if you need to. But you might need to take a slightly different approach to some of the, data use rights for Europe versus the US, depending on what you're trying to do, if you want to take advantage of a more permissive regime in the US versus the EU. And that comes up a lot at the moment because everyone is on a data grab to grab personal data to train their AI models or improve their AI tools and technology. And the US may be more restrictive or maybe more permissive, and so you can get more data and use it, whereas in Europe we have to meet stricter conditions. So you start to see people, well, we might need to take a slightly different approach with our European customer base versus our US.
Yeah, really good points. And I just add to that, I think, as you noted, so let's say you're signing a business associate agreement and one of your goals is data reuse. To add to what Flick was saying, there are some issues with that, right? So you've agreed typically to only use the data in performance of the agreement for the covered entity, essentially the controller, if you look at it from that European perspective. Well, there needs to be specific terminology to allow you to de-identify that data and then have authorization for that. And then further, well, AI, that's a whole nother use. A lot of agreements now try to limit that kind of activity, even in the US, when it comes to these processor, these business associate relationships. So we're seeing more restrictiveness, and it flows down through those definitions. What is PHI? What, is it subject to this agreement or that agreement? And it gets very complex, and it's difficult, like we are all saying, to use a single set of terminology globally to try to address these laws that start to diverge in what's required.
Thank you. In our last 5 minutes, we do have time for about one more question that's online already. So I apologize to some questions we may not be able to get to. And then I'm going to have a final question for each of you, and then we'll pass it to Cord and Amanda.
All right. Can you speak about the difference between internal development and the use of AI and the meaning of placing on the market in terms of the EU AI Act?
Yeah, that's actually a fundamental difference. As long as it's only for internal company purposes, that would not be considered, even though the company is operating in Europe, that would not be considered as placing on the market. So placing on the market really means launching a product for clients for external use. So internal AI deployment or development would not be covered.
And that would also cover internal research and development, which I think is really important for lots of this audience as well. So if you're using your AI system for your internal research and development, that might be outside the scope of the AI Act.
I'd like to thank Paul, Flick, Oliver. Great conversation. Really important, obviously, in today's age, the ability to have a little bit more predictability when dealing with AI products is important. So I hope this conversation helped. I'm going to give you each one more minute to reply. Where do we go from here? What does it look like? What does the future look like from a regulation standpoint on AI, data privacy? I know minute's not enough, but some high-level thoughts on where do we go and how does it get better?
I don't think there's any easy way to predict where the US will go, but the signs have recently been probably no national regulation on AI directly, at least at the general level. We might see some things to protect children online, things like that. Those seem to have some legs within a bipartisan approach, if there's anything that's bipartisan right now. But yeah, generally I would expect not to see federal regulation. And so what we see typically then is the states, particularly California and other larger states with interest in this area, are starting to try to fill those gaps that they see. So we're not seeing a likely federal solution at this point.
Yeah, from the UK. So, I mean, it probably hasn't gone unnoticed that AI has also become a very politicized issue as well. And I think there's a huge momentum in the UK to make the UK a kind of center of innovation for AI. And so we've had the UK AI Action Plan, and more recently they've had a life sciences kind of plan come out. And it's very, very clear that the UK wants to be a center for innovation, particularly for the life sciences space in the AI space. So I think that's going to feed through into their regulatory approach, which we already know is a much more, they're going with a much more flexible approach to it. But I think we're going to see, more guidance, more secondary legislation from the sort of dedicated regulators like the MHRA will be driving some of that regulatory reform to better kind of clarify the scope of some of the requirements in the UK. But I think for various reasons, they are going to go with a more permissive regime than Europe to try and capitalize on some of the advantage of that sort of pro-innovation strategy. We've got this new changes to the UK data protection laws that need to be bedded in with secondary legislation over the next year. The ICO, now going to be called the Information Commissioner, that's our UK regulator, is updating all of its guidance on things like processing personal data for research purposes. So there's a huge amount going on in the space at the moment in terms of regulatory reform, updated guidance, all with the goal of making the UK a centre for sort of AI innovation.
I would really say implementing an internal AI governance structure is the best advice currently, and that's what we see in the market, and that's regardless of any details of the UK or European or Colorado regulation. That's really the challenge, because AI is a compliance topic. It's also a risk topic in terms of cybersecurity. Artificial intelligence as well provides completely new opportunities for hackers, for attackers. So it's also a very important IT security topic, and that all needs to be covered by a new, AI-specific compliance infrastructure within a company. And that's what would be my recommendation and advice. Work on that and look who's responsible, who has the know-how, and who also has the power within a company or group of companies to enroll and enforce an internal AI governance structure.
Thank you. I'd like to thank you for this informative panel, and I'll welcome Amanda and Cord up.